Good afternoon. Welcome to Gowling WLG's Risk to Reward session. This session is titled Top 10 Workplace Investigation Cases of 2019, What We Learned. My name is André Poulin-Denis. I'm a lawyer with Gowling WLG's, and I'm part of the Employment, Labor, and Equalities group here in Ottawa. Thank you for taking the time to join us today for what will be a very interesting session. We're joined today by John Peters of Gowling WLG, as well as Janice Rubin and Cory Boyd of Rubin Thomlinson. Our presenters have extensive experience in employment law, but more specifically in addressing and investigating workplace issues. And so I'm sure that their insights will be very valuable today. The Risk to Reward series was launched by Gowling's in 2016 and is designed to help executives and in-house legal counsel stay ahead of the most important legal, regulatory, and corporate risks that face their organizations. Employers have a legal obligation to respond to workplace allegations of misconduct, and as a result, the way they respond can either create or mitigate some of that risk. Workplace investigations are more common today than ever before, and the law in this area continues to evolve rapidly and becomes more nuanced, which is why we hope that the contents of this session will be useful to you when you encounter these issues in your workplace. As a reminder, the session has been approved by the Law Society of Ontario for 1.5 CPD credits, and if you are a member of the Human Resource Professional Associations, it has also been approved for 1.5 credits, and there will be an email that we will circulate with the registration code for those of you who are members of the HRPA. So to start the session, John will touch on some of the legal obligations of employers regarding workplace investigations, as well as the role of external counsel in that process. And then Janice and Cory will present the top 10 workplace investigation cases that they have encountered in the last year, and then we'll open up the floor to questions. We will endeavor to complete the program by 6 p.m. for those of you who have other engagements. For those of you who can stay a little longer, we'll of course invite you to take part in a little bit of a networking reception. So a little bit about our presenters. John Peters is a partner at Gowling WLG's Ottawa office. He practices in the advocacy department and in particular the Employment, Labor, and Equalities group. His practice focuses on providing specialized legal advice to employers in all sectors with a specific emphasis on federal undertakings. John came to us from Export Development Canada, where over a period of 20 years he was their lead employment law counsel. John was also EDC's principal litigation counsel, responsible for providing advice on all liability-related issues and overseeing their litigation management practice group. John is well-versed in how to conduct and conclude workplace investigations. His expertise include drafting the underlying mutual respect policies and other related employment policies and protocols. John's crowning achievement came in grade 2, when he correctly guessed the exact number of jelly beans in a jar at a school-wide competition. After school, he needed a police-like escort to make it home alive with all of his bounty.
I peaked early.
Yeah. Yours sounds even earlier than mine. That's good.
Janice Rubin is the co-founder and co-managing partner of Rubin Thomlinson, LLP. With over 20 years of experience, she is a highly accomplished employment lawyer, one of the country's foremost experts in workplace investigations, and a trusted advisor to senior human resource professionals. Janice and her colleagues work across the country and have conducted various high-profile investigations and reviews in workplaces such as the Canadian Broadcasting Corporation, the Canadian Olympic Committee, and the Government of Newfoundland and Labrador. Janice has been awarded Lexpert's Zenith Award, the National HR Awards Employment Lawyer of the Year Award, and the Chambers and Partners Award for Corporate Social Responsibility and Inclusion. She is listed in Canada's Who's Who and Lexpert's leading 500 lawyers in Canada. Janice has co-authored 2 books, Human Resources Guide to Workplace Investigations, along with partner Christy Tomlinson, there it is, awesome. And the second edition of Law of Termination. She also has a forthcoming book titled The Secret Life of Rigby, What My Poodle Does While I'm at Work. No, I'm kidding, I made that part up, but she does have a dog named Rigby.
Yes. Who is a poodle?
There you go. Cory Boyd has worked with the Ontario Human Rights Commission, the Ministry of Community Safety and Correctional Services, and Toronto Community Housing as an in-house investigator and human rights consultant. At Rubin Thomlinson, he continues to conduct workplace investigations and workplace assessments for clients. In addition, Cory assists employers in developing systems to ensure compliance with legal obligations, including those relating to the Ontario Human Rights Code, the Occupational Health and Safety Act, the Canada Occupational Health and Safety Regulations, and the Accessibility for Ontarians with Disabilities Act. He also delivers training to staff at all levels on their roles within these processes. In addition to being a terrific lawyer, Cory is also an excellent point guard. In fact, he faced off against NBA 8-time All-Star Steve Nash about 30 times, including once when he beat, his team.
I didn't.
Not you single-handedly.
To be clear.
His beat Steve Nash team to go on to be the BC Provincial High School champions.
Right.
Cory will also moonlight on your basketball rec team.
Nice.
So please, John, if you, I'll hand the floor over to you.
Okay. First of all, I don't have a slide deck, which is the first time I've ever done a presentation without a PowerPoint. So I'm sort of flying without a net. My presentation is only going to be about 15 minutes long or less, I hope. It's 3 parts. The first is talking, it dawned on me as I read the title of this seminar, Top 10 Workplace Investigation Cases, and I'm going to talk to you about your statutory obligations. Because I don't think any legal seminar is at all fun if you can't get into the regs. So I'm going to talk about the statutory context in which you find yourself. I'm also going to talk about the role as Andre stated, the role of counsel in relation to workplace investigations. And then taking literally a page from Janice's book, which I am going to endorse throughout this presentation, unbeknownst to her and Cory. It's an excellent book. I'm going to just talk very quickly about investigation triage and how important that is to get that right at the beginning of the process, all within the next 12 minutes. So your statutory context, you're either federally regulated or you're provincially regulated. So we're going to talk about the provincial regulations and statutes, which are effectively, whether it's federal or provincial, it's just a codification of your obligations, your legal obligations with respect to a safe and healthy workplace. In Ontario, it's the Occupational Health and Safety Act. As you know, it was amended, I believe, in 2016 to include Section 32.07, which talks about the employer's obligation to investigate, not just when there's a complaint, but when they're aware of an incident. That's a very important part, and I know Janice and Cory are going to touch on that. What is appropriate in the circumstances? There's also an obligation under the Act to provide both the respondent and the complainant with the findings of the report in writing and the corrective action that's taken. We're going to talk a bit more, and again, Cory and Janice are going to get into it, but what is an appropriate investigation in the circumstances? There's some talk about, and we're going to try and talk a little bit about whether you do an investigation or you try and resolve it informally. In the past, when I was at EDC, certainly we looked at informal resolution and not going through the investigation process and trying to resolve conflicts that way. It's clearly the law is advanced, the law is more nuanced, your statutory obligations are more set. And so basically your ADR or mediation proposals do not excuse you from conducting an investigation. So you're basically stuck with investigations, which I think is a good thing. In addition to the Occupational Health and Safety Act, always be cognizant of in Ontario, the Ontario Human Rights Code, because discrimination issues can also be part of harassment and sadly also workplace violence issues. So there always can be a human rights element, or not always, but there can be, and there could be remedies that are sought by the employee through that legislation. Now the federal sphere. So if you're regulated by if you're a federally regulated employer, you must adhere to the Canada Labor Code, as you may know, my favorite piece of legislation, and the new amendments and regulations that are coming, which I say carefully. You may know about Bill C-65. It received royal assent on October 25th, 2018, but it's not in force yet, but it's going to become in force this year. There are some changes, and the changes are meant to deal with workplace harassment and workplace violence prevention. There's a new definition of workplace harassment and violence. And there is a positive obligation to provide workplace training for all employees. There's also a restriction on the ability of workplace health and safety committees and other HR groups from investigating harassment and workplace violence issues. The most important part, I think, of Bill C-65 are the new proposed regulations, which again are not in force. But sections 18, 19, and 20 of these proposed regulations are quite interesting and new, and it's a new development in this area of the law. Number one, they have a clause that is similar to 32.07, which basically states there's an emphasis on conciliation, so this informal or maybe non-investigative dispute resolution process. If that doesn't work, and the principal, which means the complainant, they use the term principal instead of complainant in this legislation and regulations. If the principal wants to proceed, you must investigate. So there is that obligation to investigate. Are you ready for it? Section 20, this is exciting. Or not exciting, or may strike fear into your hearts of HR professionals and in-house counsel. Section 21, now if these regulations are put into force, and we believe that they will be, the employer, the principal, again, what used to be the complainant, and the responding party must select a person to act as the investigator. So now it's not up to the employer to select the investigator unilaterally. All three parties have to agree on an investigator, which is a different process. It's almost like literally an arbitration or mediation where there's a panel and you have to decide on the sole investigator or arbitrator. It also beefs up who can investigate. So I'm going to talk a little bit about investigation triage in a moment, but who can investigate under these regulations, section 20.2, the investigators have to be trained in investigative techniques. They have to have knowledge, training, and experience relevant to harassment and workplace violence. And they have to have knowledge of the Canada Labor Code, the Canadian Rights Act, and any other federal legislation that applies. So you can't just hire the $50 an hour ex-cop who now investigates workplace cases. You have to hire Janice and Cory.
No, it does not say that in the regulation. We tried lobbying for that, but it didn't work.
Well, they're not set in stone yet, so there's
Oh,
still,
it's an opportunity.
I did see your picture in the little Gazette notes. Okay, so now I'm going to move from, I hate to walk away from regulations, but I'm going to talk about the role of counsel, your counsel, whether internal or external, what Gowlings can do or what your internal counsel can do for you during the investigation process. I've broken it up into 3 different stages. The first stage is the beginning stage. The first stage is what I would call interim measures. And that's when you talk about, and you have to design, separating parties and witnesses depending on the nature of the complaint, and rules concerning contact. Not just, again, the parties at issue, but also witnesses. Because you don't want, and we've seen in certain cases where witnesses have been known to talk to each other, that maybe were part of the media. I don't know, Janet, do you have any experience with that? You want the witnesses you want them to maintain their testimony, preserve their evidence as their own evidence. So there are issues at the very beginning about separating people. Communication issues, who needs to know, what do you deal when you might have a high profile case. Keeping the matter confidential. So again, it's part of communication and who needs to know, but it's also for the parties and witnesses. When I was in-house counsel, we would certainly have our HR professionals would instruct the parties and the witnesses that they had to not talk to each other about this specific case and to keep it confidential. They're not allowed to share anything they know about the case with any other person not involved. And then preserving evidence, which again is preserving their evidence, but also preserving the electronic records, which, as you know, are many thousands and thousands of pages of documents, and your ability to preserve evidence and to go in. And there's been, in my experience in overseeing investigations, is the importance of being able to that evidence that is oftentimes critical to the case. So that's the beginning. You also, I think in-house counsel and Janice and Cory, we talked about this earlier. There's a rule for when you move into the investigation process, helping the employer as counsel, helping the employer and the investigator nail down the mandate and set the parameters. And even if you have a big complaint, you might not want or need to investigate everything, because not everything might be appropriate with respect to your legal obligations. So setting the mandate early so you know exactly what they're going to investigate and how wide it's going to go, which can change over the time, but it's really important at the beginning to set that properly. And then we're going to talk about this in my last stage, which is investigation triage, but choosing whether you choose to investigate or not, as discussed early and said, regulations and statutes, you basically don't have much of a choice anymore. It's rare that you don't have to investigate. There's still opportunities, and we can discuss your potential of resolving it informally. Secondly, and maybe most important, choosing the right person to investigate. Again, the regulations under BC 65 require people to have specific expertise and knowledge of the law. You need to deal with matters during the investigation. So things can come up during the investigation that you didn't foresee. Or we had one case, and I don't want to get into great details, where the investigator went sideways and we had to stop the investigation because they overshot their mandate. They were providing legal advice to one of the parties, and we had to stop the investigation and start it all over again. So you have to be there. It's really important for legal counsel to assist the employer and assist HR in managing and assist the investigator to the extent possible in making sure that things run smoothly and dealing with things as they come. And then, of course, there's a review and acceptance of the report when it's written, choosing corrective action, discipline, training, reconciliation, if any, releasing the report results and corrective action. Again, your obligations under the Ontario legislation is quite clear. And then a lot of people forget about post-report action, administering discipline, dealing with the fallout from that, in case it involves termination. Sometimes there's internal communication. There is training. There's going to be training. Everyone, Bill C-65 requires you to train, but there'll be training, and there could be lessons learned as a result of the investigation. And then a policy and protocol review and update. So there's lots of things that counsel can do, and which is why when my last part, we're going to talk about the triage, why we recommend, or we, at least at Gowling, think that our role, we want to remain your legal counsel, your independent counsel, or if you're internal, your internal counsel, you want to remain sort of separate and apart from the investigation, and you don't want to be the investigator. So just to go through the investigation triage really quickly, again, I'm plugging Janice's and Christine's book. This is excellent. It's a Bible of, did you say a third edition is coming out soon?
No, I did not say that.
No, that was my joke.
Yeah,
okay.
no, that was my nightmare, not a joke.
Yeah.
But is there an e-version?
No, there's not. But I will say this about that book. The difference between the first edition and the second edition was that we wrote another book. It was not just revising it. We just basically threw out most of what we said. In fact, when we went to review it, we were horrified by some things. So if you still doing your practice by the first version, throw that out. So it's a much bigger book. So that's why there's not going to be a third book.
Okay.
Yeah.
It's perfect. That's why.
Yeah. No, it's because you will
no, it is.
kill us.
It's so good. It has so many insights and so I'm preparing
Did
for
you like
this.
the pictures?
I love. It's mostly cartoons, and that's how I learn.
It's a graphic novel.
I can't actually read. I'm just looking at. This is a grocery list that this is all by memory. Okay, so just quickly, because I know I'm running out of time. Do you investigate? We talked about that. Your obligations. Who should investigate? You have to decide between internal and external. And when I say internal, there's great HR professionals, and there are cases and circumstances where you use an internal investigator. There are problems. Janice talks about them. One of my favorites, the U factor, or EU. If you're Jimmy Fallon, you can say it properly, where there could be very delicate issues that are being alleged, and maybe as the HR professional, you really don't want to investigate the senior VP's sexual preferences or unique views on the world. So you might want to give it to an external person. Also, there's a potential, and it's not really good for the respondent. There could be a presumption of bias if the HR department is consistently saying no, there's no harassment, no workplace violence here. That's not great for the respondent because the complainant and others might think, well, that's because they were investigating Mark Jocelyn, and he's a big deal, and so of course he's innocent according to the HR department. But if you have somebody independent, then that's also good for the respondent because it shows when they are exonerated, then it shows it was an independent investigation, and it does provide some comfort to both sides. I think if you have somebody more independent. The question of do you use internal counsel to investigate these complaints? My number one rule when I was internal counsel for EDC was never, because there's so much conflict as internal counsel that you have. Because one day you could be cross-examining the respondent on this complaint, and the next day you're taking instructions on a file. And that's just problematic, especially if you don't have 24 lawyers in your department. So I never saw it as a good choice. You can use external counsel. Obviously, Janice and Cory are external. They are lawyers, but when they come to you as expert investigators. There's another role for external counsel to act as your legal counsel. Anyway, bottom line, again, according to the regs, that you have to be properly trained and experienced. One of the jobs that we can do is help you find good counsel. You need to find good investigators. You need to find good investigators, and we can help you find good investigators. Q, Cory, and Janice. The last thing I'll say is the last external investigator you may need is a police officer, because the acts of violence, workplace violence, are and likely are criminal, and there could be an ongoing and parallel criminal investigation. Again, I don't know, Janice, you've had any experience with that, maybe. And maybe we should talk about that. So you could be dealing with an internal investigator. You can be dealing with an external investigator on the workplace harassment and workplace violence issue, but you could also be dealing with a coinciding parallel criminal investigation. Something to be aware of. And that's it, and I did all of that in 100 minutes. No. Sorry, go ahead.
That's good.
We're good.
Sure. Well, hello. Thank you for that, for warming up the audience and for giving us a statutory framework. It's really nice to be with you. It's nice to be in Ottawa. I was in the cab and saw the lovely skaters going down the canal, which is a treat. So because we are workplace investigation geeks, we actually talk about these things. And when we get to the end of the year, we think, well, what were the cases that were most interesting? What were compelling? What did we rely on? What did we talk about? And so this is kind of an arbitrary list from us. If you were doing your own list, you might come up with other stuff. But we think that there's some really good sort of nuggets here in terms of an investigation practice, whether you are an internal lawyer, HR person, or whether you're an external lawyer advising a client, or just you're interested in the zeitgeist, because these cases increasingly end up on the front page of the business section of the Globe Mail, or the Toronto Star, or God forbid the Toronto Sun, and they're just kind of interesting. So sort of with that kind of expansive, personally curated list, we want to sort of tell you a little bit about sort of the themes that we extract. We've got a case talking about procedural fairness and investigations. We have a case talking about structural independence. That's my favorite case the whole year. The right to remain silent. So we're going to talk a little bit about sort of the interplay between investigations and criminal investigations. post-employment harassment, which is funny. Like really the employment relationship ends and you're still harassing your colleague. So we've got a case on that. It's rather extraordinary. Sanctions for sexual harassment. Cory and I were talking about this case coming over. We've got a great case for you. Interim measures. So to your point, John, about one of the things you think about in triage, and that sort of what is the content of an investigation that is appropriate in the circumstances. Appropriate in the circumstances being a term of art under the provincial legislation. We have a flawed investigation case along with what happened to the employer in terms of exposure to damages, because there's always got to be one. This one's great. We've got a case on discrimination, and we've got a case involving grievance arbitration, third-party standing. So I think, Andre, you want us to finish up at about 5:45, 5:50? Okay, and then I think the plan is to take some questions. But that being said, we're pretty informal. So if you're dying to ask a question as we're talking, by all means, don't wait to the end. Put your hand up and interject, and that would be fantastic. Okay, so with that, the first case is a case called Chapman versus Canada. Now, your firm has a connection, I believe, to a case that was decided a number of years ago by Mr. Justice Schoen. Was that not your case? Zinn, and it was Schoen. Whoops, there's a weird conflation. So we brought you another Justice Zinn chestnut because Justice Zinn continues to be interested in workplace investigation cases. So he was a partner. He was a part, so it's a case that belongs in this firm. It's a tradition, right?
So he's super smart.
He's super smart. He does seem to have a real interest in workplace investigations. So this is relevant. Here we are in Ottawa. What happened was the facts underlying this case, I will just say, are very, very, very fast, very sad. So it arises out of a suicide, sadly, of an employee who reported to the Ms. Chapman, who you see in the style of cause there. And ironically, Ms. Chapman was the director, or not ironically, director of investigations in the Office of the National Defence and Canadian Forces Ombudsman. And what happened was Ms. Chapman had been the employee who reported to Ms. Chapman had been involved in an internal disciplinary process. And then sadly, he died by suicide. So there was concern in the employer, in the office, that somehow Ms. Chapman had mismanaged this, given that very sad result. And so an investigation was launched. There had been a letter that had been sent accusing her of misconduct. So the employer began an investigation. And what's really important to understand in this specific circumstance is that the investigation was under the Public Servants Disclosure Protection Act. So in that act, what it says is if you were subject to an investigation under the act, you are entitled to capital P, capital F procedural fairness. Okay, now when Cory and I and the rest of our office do investigations, what we are obliged to do is sort of appropriate in the circumstances, which is sort of small f fairness. It's not exactly procedural fairness. It kind of mirrors it. It's probably 85, 90% there. But this is like the term of art, capital P, capital F, procedural fairness. So what happened to her is she received a set of allegations, and they were not particularized. It simply said that she had engaged in gross mismanagement, brackets, disciplinary action. And therefore, she didn't know before her interview exactly, specifically, what wrongdoing she was alleged to have engaged in. And in fact, given her role, she knew enough to ask for more. No more particulars were forthcoming. The investigation proceeded, and the investigator, in addition to wanting to interview her, also interviewed witnesses. And in terms of the sequence, the witnesses were the witnesses' information was not presented to her to respond. And so that was considered to be a flaw in the investigation process. The other interesting thing about the witnesses' evidence was that Justice Zinn really focused on not only understanding the allegations, but that this person who was subject to the investigation had an interest in understanding the evidence. Now, this is really interesting. You'll hear this again in some of the cases. And when you think about your own practice, like what we typically have focused on is, okay, what are the allegations? But now when we do the summary, not all of us, but a fair number of us are now thinking about including key pieces of evidence if we have it when it's going to the respondent. So I'll give you an exact example that sort of comes out of the principle of this case for something I recently did where a respondent was accused of engaging in sexual assault after a party at the office. And what I knew and what the employer knew was that there was a record from the taxi that he took. It was a corporate taxi account, and they could see that he had used the taxi chit sort of the morning after the alleged assault occurred, and that the journey began near the complainant's apartment. So that's a piece of evidence, right? That's not the allegation, that's a piece of evidence. So I thought, as a matter of fairness, in part because I had read this case, that I should disclose that. So I did when I prepared the summary of allegations. This is what she says, and in addition, we have this. So at the end of the day, because of these flaws, another flaw was that she was prevented from taking notes during the interview. So the investigator said, you cannot take notes during the interview. It doesn't make any sense. I think it was a odd, twisted concern about confidentiality and not taking the evidence out of the room. But that, in our opinion, is a no-no. You can't forbid somebody from doing that. And as a result of all of this, the report said that she did engage in wrongdoing. So she goes off to court and has the decision basically set aside. Justice Zinn said that this was truly unfair. This was the process. And by the way, this was an external investigator on the vetted external investigator list in the federal government. So we'll have more to talk about that. But this process was not procedurally fair. And in fact, Justice Zinn says that the other failing is that she was entitled to know what the decision was and be able to comment on it before it was sort of elevated to the ultimate decision maker. So it's a really yet another interesting case from Justice Zinn. And I think what it does for employers, it prompts you to really examine, are we being as fair as we can be? Even though we may have done investigations and done the same kind of thing for 15 years, with the sort of additional scrutiny in the current environment, can we be more fair? And what would prevent us from disclosing evidence, for example, to a respondent? Is it because we really want to kind of play gotcha with the respondent? But does fairness dictate that? How will the whole process look on replay? What's great about Justice Zinn is he shows you how the process looks on replay, and it's probably at odds with what the investigator intended necessarily, but it doesn't look so great on replay. And at the risk of sounding hugely self-serving, in the Wild West of external investigators, and there are many, many good external investigators, and they don't all work at Rubin Thomlinson. I will say that there are fabulous people out there who do a great job, but you really have to be careful, because what happens is you take your baby, John's baby, and it goes to us, and then if we mistreat the baby, it's still John's problem. So you have to be really, 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 really careful. I think the content of fairness is a bit of a moving target. It's evolving, and it's really something to think about. So that's one of the reasons why we loved that case. And the risk, just to be really clear about this, is that although it has never happened to us, theoretically, if a respondent talks to us, and we typically take notes and we also will make a recording, theoretically, the Crown could obtain a production order and get those statements from us and use it to contradict what the respondent has to say. Theoretically, as I say, may not always be thus, but it's never happened. There have been times when we've been so worried about it, we've gone about like photocopying our entire file because we think, and they come in and they take the file away, right? We've done that with some cases, but it's never happened. So I think in that situation, when I knew that the respondent was, and his counsel and his union were seriously considering what they were going to do in this situation, I did feel fairness then dictated that not only was it a he said, she said, but that in fact, I had some evidence that seemed to place him where she said he was. The only conversation I'd ever had with him was a process conversation. He had never said to me, I was there or I wasn't there. But I thought as he considered his options with us, he needed to have that disclosure.
Do you provide the respondent with all the witness testimony that you have? Like how detailed do you get in providing the evidence that you've gathered today?
If we receive witness evidence that contradicts the evidence of the respondent and we intend to rely on it to make our findings, we would share it with the respondent before completing our investigation in some way.
Yeah.
In some way. And it might not be the exact same way, but it would be in some way. They would get to know that there are witnesses who contradict them and be able to speak to that. And we would sometimes do that identifying the witness, but often you can do it without identifying the witness because it doesn't matter which two people in the hallway heard the fight, or whatever the case may be. Right? So.
And here's the other potential problem is that I think, and this sort of ties into the next case, the TTC case that I said I would show you, and I somehow have managed to leave in my hotel room, so I'm not going to show it to you. But I wanted to show it to you because it's short, and I think if you're going to read anything, you should read on this case. So it was the City of Toronto's ombudsman. She calls herself the ombudsman, Susan Opler, and what she was doing is she was investigating an investigation. So there had been an incident on the TTC involving a young man, a young black man, who had been sort of tackled by one of the fare inspectors, and I gather that it was filmed by some passersby, and it ended up in the media, and it looked terrible, and it prompted the TTC to do its own investigation, and then the ombudsperson or the ombudsman wanted to look at the investigation and whether it was sufficient or not. And in the end, she decided that it was insufficient. And one of the reasons why it was insufficient is that she looked at a couple of biases. She talked about unconscious bias, which had not been explored in the original investigation. It was a young black man, and there were certain things about the fact that he was apprehended, the fact that he was tackled, the fact that he was a young man that seemed to suggest maybe a disproportionate amount of force. And we know, in the world of unconscious bias and racial discrimination, that's often like the presentation where there's just too much force. But the other bias that she talked about that she was concerned about was confirmation bias. And this is how she talked about the bias that is exhibited by internal investigators when they kind of know the people or they have a particular outcome, maybe it's a desired outcome, maybe this is unconscious. And here she was concerned there was some indicia of a confirmation bias. So returning now to the issue of witness evidence, if you assume that one of the extra challenges that you have, I mean, how many people here are an internal investigator or have some contact? One? Okay.
We're talking to you.
We're talking to you. I'm sure you are a lovely person. But there are challenges. There are certain challenges when you are the internal investigator, right? And let's just assume that some of those challenges and some of those biases you are aware of, and let's just assume that some of them you're not. If you marry that bias with, I think I can hold back some evidence, I think you're asking for trouble, because I think holding back the evidence may be the playing out of that bias. It may not be, well, let me think about this. If I hold it back, is it a legitimate testing of the credibility to sort of ask the question and say, but aha, I have this that contradicts you. Maybe. I understand that, but I'd be concerned in the hands of internal investigators. That's maybe how it would get used. Even then, it does help you a little bit with credibility. But honestly, having sometimes done that, like between interview number 1 and interview number 2 with the respondent, people do forget, or people just remember things in different ways.
And are you doing similar things with the complainant to test their credibility? Yeah. Because sometimes I've seen it with internal investigators, sometimes they don't, right? They go at the respondent's credibility and they don't do the equivalent with the complainant. So
It's tricky. So before I turn it over to Cory, just as I'm advocating for you to read the case that I thought was so important I left in my hotel room, let me tell you the other problems with this investigation. So lots of things that she said they did right. They did an investigation. They did it quickly. They committed resources to it. They had sort of an internal security person do it along with the human rights consultant, so they covered both angles. They did write a report, so those are all good things. And if you've been following the development of the case law, you will know that those things are big deals because sometimes employers have not always done them. But she says, but there were some problems that ultimately made the investigation sort of unfair. So the investigator should have asked more questions. The investigator didn't understand the totality of the incident. She wanted to hear more about various things. The investigator didn't make clear factual findings. So what the investigator did is it looked at the whole problem and then delivered kind of an answer at the end, but didn't, we talk about it in the office, they didn't show their work. They didn't say, okay, so this is what the complainant says, this is what the respondent says, and these are the factual findings. This is how I made the factual findings, this is the evidence, and now this is the meaning of those factual findings. Cory talks about the what happened, and then the so what, right? And then for lots of you internal, the now what. So this investigator missed that, didn't, as I say, consider bias. And this is really interesting, and we'll talk some more about this, I think, with Bill C-65. This was an internal investigation, and the ombudsman didn't say, thou shalt never do an internal investigation. That was not her message at all. But what she said is, you have to put more safeguards around your internal investigators. They have to be not only independent or they not only have to be competent, which is the language in Bill C-65, but they have to be acting in a structurally independent context. So your internal investigators have to sit somewhere else in the organization, and they can't be socializing with their friends who have some say in what's going on. So the implication is that they can't sit in HR, actually. So, maybe we'll have an opportunity to talk about this. We talked about this before, that one of the great opportunities, I think, for counsel right now is to help their clients figure out this sort of structurally independent office or role, so that you're not looking like an extension of HR or whatever, a finance. And it's a really interesting idea. Some
employers use their compliance department to do it and tries to sit apart, or their auditing department to do it.
You go for it.
I will leave my. The risk there is sometimes those compliance investigations are less familiar with concepts of fairness within the investigation process, but that's that's a conversation for another time.
So it's a fantastic case. You can Google it if you just look at City of Toronto Ombudsman investigation of the TTC. It's February of 2019. It's just and it's beautifully written. She did. There's just something in it for everybody. So that was my favorite case. Okay, over to you.
Okay, I'm cognizant of the time, so I'm going to move through the facts somewhat quickly here, but they're interesting and relevant. So I am going to talk about the facts a little bit. This is a case involving a school board, and the situation was that a parent brought two children, 11, 12-year-old girls, into the school board office on May 3rd, the date is relevant, and raised some concerns about the behavior of a teacher. And the concerns ranged from he put nail polish on them with highlighters, to he gave them a massage. He told one of them he had photos of her in his home. So it was kind of a range of concerning behaviors brought to the board's attention. The next day, the board interviewed the parent, both students, spoke to the principal, and interviewed 7 classmates. So they got on it quite quickly. And then the end of that day met with the respondent, who was not told what the investigation was about, nor were they given any particulars, brought into a room and said, you're being investigated, here are the allegations, and read to this individual the 7 allegations against them. So I was going to do a little aside here, how that's not best practice, but I think we've covered it. No information provided in advance. And so the respondent and their union rep left the room, came back in about 15 minutes later, and said literally, yes, no, 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 yes. I think that's 7, right? Essentially, one-word answers to the 7 alleged things. The ones they were said to have done, by the way, were the highlighter, nail polish, and the compliments on, oh, you look great, I like your shirt, kind of compliment. They denied everything else. So the board tries to ask some more questions, refuses to provide any more information. Meeting ends, the respondent leaves. In the meantime, the board now reports the teacher to the Children's Aid Society, triggering an investigation under their process. The parent has contacted the police, triggering an investigation there. The board emails or sends a letter to the respondent saying, these are the additional questions we want clarified from you. And the respondent says, given the ongoing investigations that have now been started, I'm not going to provide any additional information. And the respondent is suspended without pay as a result of their non-participation in the investigation and the impact that non-participation had on the board's ability to conduct an investigation. Now, what's interesting is life goes on, summer goes on. The Children's Aid Society investigation ultimately comes back as inconclusive. The police declined to press charges. No real interaction between the teacher and the board. And in July, the teacher writes the board to say, "Do I have what am I doing in September? Where am I working in September?" And they said, "Well, there's still these outstanding questions." And he said, "Oh, well, okay." And then provided detailed, long responses to all the outstanding questions, and ultimately was, exonerated in the board investigation. They concluded that the allegations were unsubstantiated as a result of the responses. So the grievance related to the suspension without pay. And what was nice about this is that it was a tidy question, which was, can you discipline somebody for their failure to participate in the investigation, period? Because normally what happens is you have non-participation plus findings against the person who declined to participate. That's usually how this presents. And so the decision maker said, there's no question that you can draw an adverse inference from a respondent's non-participation. There's no question that you can make findings at the end of an investigation absent their participation if they decline to participate. Can you discipline them for their non-participation alone? And what the decision maker said was essentially yes. That the right to remain silent is not all-encompassing and not consequence-free. And any right to remain silent in the context of workplace investigation may be outweighed by the surrounding circumstances of the conduct issue and the relationship to the employee's work. What they said was, given the nature of these allegations, given this person's role in the application of the Education Act to teachers, given the fact that this wasn't off-duty conduct, this was classroom conduct, these circumstances required an explanation, and the failure to provide an explanation in and of itself was sufficient to ground the discipline. So, the right to remain silent, as I said, is not consequence-free, even if it's understandable sometimes when there's the overlap between these two investigation processes. I don't know if you spoke a bit to the criminal piece already. I don't know if there's anything to add on that, but
okay.
I'll pass it back. Okay. My job is catch up, as you can see.
No, I'm going to catch up because I'm going to do the next one in a minute. So this is a really interesting case, Duverger. From the Canadian Human Rights Tribunal. And it had to do with the interpretation of Section 14, Sub 1, Sub C. So there's a statutory reference for it to make you happy, John.
My favorite part.
Yeah. Do you want to say 14, 1C? Does it make you really happy?
It's
excellent.
Super happy.
Excellent. Okay. And what it says is, it is a discriminatory practice in matters related, these are the critical words, in matters related to employment, to harass an individual on a prohibited ground of discrimination. And so the question is, does that apply to this situation where a supervisor sent a former employee, so that person had left the building, a series of inappropriate emails, including the following comment, quote, "You are the biggest idiot I've had to work with in 25 years, so go back to your country because over here you are just a parasite." And it continues, "You can find a room in the psychiatric wing of the hospital of your choice." So we're really hitting all sorts of prohibited grounds of discrimination there, race, disability, all sorts of things. And so what's really interesting about the answer to this question is yes. Yes. When you use the words in matters related to employment are sufficiently elastic to cover that situation. And the reason why we include it, you could just see narrowly as a case involving statutory interpretation, but to signal to you that there seems to be an ever widening net of employment-related, workplace-related, nexus to employment, where these general rules apply. And so this case reminds me of Shrink. I think it's Shrink from the Supreme Court of Canada from a few years ago, where there was, you may know the facts, but basically there were people who were not in traditional employment relationships with each other. There was a bunch of different subcontractors. People behaved badly, and still the Human Rights Code of BC applied. And so, if you're sitting there at your desk thinking, I'm not sure if I have to investigate. I'm not sure if our policy covers. I'm not sure if the statute or the regulation covers. Just know that the underpinnings of that is that the way they're being tended to be interpreted now is pretty expansive. So that case is an example of that.
And Bill C-65 does talk
Yes.
about your requirement to investigate. It becomes known within 3 months of the employee leaving. So you actually have an obligation to investigate.
Post departure. So
That's new.
That's new, which is quite interesting, because often these matters come to light after somebody has left, because they don't necessarily have to, they're not necessarily fearful about losing their job because they've already left. But this case was different because the harassment happened after the person had left.
Right.
It was not enough to harass while the employment was going on. They had to continue. Lovely. Okay, so is yours the next one?
Yes.
Okay.
Okay, so this case involves a QP employee who grabbed and squeezed the breast of a female coworker in the workplace.
There's an opening line.
Yeah, just once, which became relevant to the arbitrator. Just once, and the city fired them. And the matter went to arbitration. The arbitrator, hearing the grievance, substituted the dismissal with a 9-month paid suspension. And essentially what the arbitrator...
Do you see Mark's face?
No, I know this is at the low end.
Yes. So the arbitrator concluded that this behavior was at the lower end of the spectrum because of a few things. One, it was a single incident. Two, there was no evidence that the complainant was traumatized by having their breast squeezed by a coworker in the workplace. They referred to it as an impulsive, ill-thought-out, isolated incident. And they said there's no evidence of persistent conduct creating an unsafe environment. They said it's troubling that the employee did not admit, so the employee never admitted it. It's troubling that the employee did not admit the behavior, but the risks of the returning employee are minimal. And noted that there was little contact between the complainant and this individual in the past. So the matter ends up in the Court of Appeal, who, rightfully say, you failed to consider that this action is a sexual assault, which is
The criminal act.
I mean, we laugh, but it's kind of shocking. But you failed to consider that this action was a sexual assault, and a sexual assault is sexual harassment in its most serious form. And they noted that the arbitrator had used minimizing language. They referred to it as a personal assault, but also as an incident, as contact between them, and as conduct. And in fact, in reviewing the decision of the arbitrator, they found that language alone, that minimizing language alone, was unreasonable, right? Which is what they're looking for. A few things that the arbitrator noted that I just want to kind of note so that you don't note it, or you don't let your investigators note it. One thing they said is that this was not, and I can never say this was not quid pro quo harassment. It was not that type. It was just more about the work environment, and therefore it was somehow less serious. And the fact is, if there is a connection made between the behavior and your work conditions, that may be an aggravating factor that makes something more serious. But the absence of that characteristic doesn't make it less serious, if that makes sense. They also said, and I hope this is not news, the apparent lack of trauma for the complainant was not an appropriate factor in determining this less serious. And it's the same idea. Evidence of trauma may be relied on to make this to be seen as more serious, but there's also no right way for a person to respond to a sexual assault. And so the evidence of a lack of trauma isn't going to somehow make this less serious. And then they said the fact that there was no evidence of a pattern and the fact that there was no history of contact between them misunderstood the test, because you have to consider the impact of this person's return to the workplace on the workplace as a whole. And the duty to keep a safe and harassment-free workplace doesn't just apply to the complainant, but applies to all the people in your workforce. The employee had been trained. The employee said they understood sexual harassment. The employee acknowledged that the behavior, if it were true, would be sexual harassment. And nonetheless, they did it and didn't admit it. And so the court said they could not be trusted and that there are real concerns about the city's ability to provide a safe and respectful workplace to all should they be returned after this 9-month suspension. And so the original remedy of termination was restored.
So what we were talking about on the way over is, I'm not sure how we call this bias, but kind of ignorant bias. Like, and this is something to watch for, as counsel, but also, as the internal, not that you would be ignorant, but as somebody who's supervising other people, is you see these biases where people, and the original arbitrator was female, by the way. So you think that life experience might give her more insight into what it was like to have a breast grab, but I guess not. But it
is a potential, and I don't. It is a potential form of confirmation bias in which you say, this isn't a big deal. And so everything that I can consider, I'm going to interpret in a way that says this isn't a big deal. Right, and anything that might suggest it was a big deal, I'm not going to pursue or go down that road.
Or it's just ignorant bias, which is just push aside all the messages we get in this culture that minimize that type of workplace behavior, and really think about the harm that is caused. Like, really think about the offense of grabbing a woman's breast in the workplace. Terrible. So it's it's another way of understanding the case, is that kind of bias that's operating. Okay, you can do the next one too.
Yes. And this one I am going to do quite quickly. This was a sexual harassment complaint. The employee brought a sexual harassment complaint against a supervisor in the workplace, and there was an internal investigation that was conducted, and ultimately the allegations were unsubstantiated in the internal investigation. However, the employer at the end of the investigation said, for 3 months, we're going to not schedule you two together. The workplace had sort of there was like a pub and a banquet hall and a conference center, so they had some options. So they said, for 3 months, we're not going to schedule you together. So the union, there's 7 grievances brought, and in the context of these 7 grievances of sexual harassment, the union sought interim relief measures within that process. And then what they saw was that until the grievances had been resolved, they would not be scheduled together. So basically an extension of the 3-month agreement that they put in place. And the employer fought this. I'm not entirely sure why. And the arbitrator looked at the situation and really just looked at the balance of harm and convenience and said, there's no harm to the employer of maintaining this during the grievances. How we know that? Because you did it for 3 months voluntarily and it was fine. There is a potential harm for the griever, should they be required to work a shift with someone who is their alleged harasser. And so the decision was made seemingly quite easily to extend these interim measures that were put in place within the context of the workplace investigation, and to maintain those going forward through the context of a subsequent legal process that flows from that investigation. So it's just a good reminder for employers. The investigation might not be the end of it, and it may be appropriate to extend interim measures that were in place during the investigation during these subsequent processes.
Okay. Moving right along. Now, this case, we should pause for a moment. We were talking about this before. St. Joseph Healthcare Hamilton case. So under the Ontario statutory regime, that if you fail to conduct a workplace investigation, having received the prompt of awareness, the Ministry of Labour can come in and order you to do one, or order that you have one done by a third party. That's kind of the teeth to the requirement, and I think I'm not sure if it's the only statutory requirement in the country that has that, but that's the enforcement mechanism. And since this new regime started a number of years ago, they have not been shy in ordering this.
And the timelines can be very tight.
The timelines can be very tight, because we sometimes get emails from these organizations, can you do a full investigation in 5 days? So here's what happened in this case, and it's just very interesting. So it starts by the hospital receiving an order to investigate a complaint of workplace harassment. So it did. And then it sent the report to the complainant and her union. The complainant was unhappy. So again, involved the Ministry of Labour, saying that the investigation was inadequate. It brings another, so the Ministry of Labour issues another order, and the order is, do it again, but use an external investigator. The employer brings an application to the Labour Board saying, no, please, we're appealing that. And while we're appealing that, stay that order. And that's the result of it. But what's interesting is, in considering whether the stay would be granted, the adjudicator considered the overall merit of the employer's argument that it had basically done an appropriate investigation. And what had happened was it investigated some of the allegations, but not all of them. So here's what the board's reasoning was, and I'll just read it to you because it's I think very, very helpful to counsel in working with clients in fashioning mandates. So the decision maker says this: the hospital has explained in detail why it chose the particular internal investigator, so not the external one who was ordered, why the investigation parameters were narrower than the complainant's complaints, and why it takes the view that these decisions were appropriate in the circumstances. So there's the term of art. Although the board does not have a large body of case law interpreting section 32.07, the words appropriate in the circumstances must have some meaning, and the hospital, in my view, made out a strong prima facie case for why its investigation was appropriate. So this is really interesting for counsel in fashioning a mandate. Interesting, because it leaves open the door to consider, does every allegation of everything that the complainant feels is going wrong in the workplace have to be investigated? And we know investigations are costly, they're time consuming, they're disruptive to the workplace. And I think this case sort of raises opportunity to consider whether, do we have to investigate allegations on their face that aren't necessarily, that are just obviously not harassment? And I think it gives counsel and clients sort of an opportunity to be rationally discerning of, we'll investigate some, but not all. And I will say, in the context of what we're seeing in our practice is, maybe this was an unintended consequence of the Ontario regime, but that there are some complainants who are now coming forward with, allegations that are voluminous. The 160 allegations that are voluminous about everything that has ever made them unhappy in the workplace. And look, unhappiness in the workplace is a serious thing, but not all elements of unhappiness in the workplace are deserving of the full, the full fat version of a workplace investigation. So we found that case actually quite interesting. So it may be something for you as counsel to lean into when you're thinking about what the mandate is. Investigate this, but not that.
Yeah, it's not uncommon as externals for us to, when we get a call from an employer client to say, even if some of these allegations are true, we are not going to make a finding that they are harassment. Do you want us to investigate these, or do you want us to focus on the ones that meet that threshold? And the answer is different sometimes. And sometimes they say do everything we want to know, and sometimes they want to focus on the things that they have to investigate for statutory reasons or policy reasons.
Right. Or sometimes they don't understand the difference, but really, truly the difference experientially and financially between A and B. So please tell us everything. Okay, and then the bill is $150,000, and then you wonder why you've spent $150,000 to look at allegations that are 95% not harassment. So it's a really important conversation to have with for your clients. It's really something to think about. So that case gives you sort of the foundation to have those conversations, it seems to me. Oh. All right. Still me. Okay. All right. Still me. So no, I thought it was you, Francis.
Sobeys.
No, Sobeys.
Sobeys? Okay. So Sobeys, I'll just tell you a little bit about very quickly because we're running out of time. This had to do with a woman who was in the produce section of Sobeys, and she had been maltreated by a coworker for years and years and years. And the employer, and as documented in the decision, did not do very much about it. She'd raised complaints. They hadn't, this was, any case that we do involving like food or a kitchen has a knife, as somebody brandishing a knife, this one included. And finally, they ended up firing her after she mislabeled a food product, sort of misusing sort of the best before date. So it's an interesting case. It's long and windy. It's kind of difficult to read, but it's sort of a juxtaposition between the heavy hammer of violating something in food safety, but not doing anything after years of harassment. So here's what the facts of it's a small claims court. So I'm not sure if it was a judge or I'm not sure who adjusted the piece, but anyway, whoever was making the decision. Why I have found the plaintiff's termination was untruthful, misleading, and unduly sensitive. So she says, summarizing my findings of fact, violence and harassment in the workplace prevention policy. Mr. Randall did not follow this policy. Mr. Randall only took notes of complaints when he considered them to be a serious matter. So he again, there's a sort of a confirmation bias. He only made notes of things that he personally thought were serious. A couple years where he ignored, like HR ignored complaints that she made. The first knife incident, the plaintiff alleges that her supervisor was holding and swinging his trimming knife while yelling at her. And while the colleague responded, "Oh, he's just having one of his days," took no notes. There's a second knife incident, took no notes. And then the terminating incident when she was questioned about this sort of food safety infraction, it was viewed as being a quasi-criminal type interrogation, which harkens back to an old case from a few years ago involving the GTAA. Arbitrator Scheim said that is not how you question somebody during an investigation. They're open-ended, neutral questions. You're not supposed to, vigorously go in then and gotcha and cross-examine. What is interesting from a process perspective is, one, this case is at the small claims court, and the small claims court decision maker was very sophisticated in terms of assessing this. She had been paid notice by prior to this case getting to the small claims court. So this $25,000 was just about the aggravated damages, and this decision maker gave her all of that by virtue of how she'd been treated. So it's another reminder that, we don't just do these investigations because the statute tells us to. In the civil context, we do them because if you don't, you're exposing yourself as an employer to additional damages. So that's why that case is included. All right. Next.
All right. Home stretch, last two. This was an interesting case out of BC. It is a Human Rights Tribunal decision. It involved discrimination based on race and color. And the context is a correctional officer who identified it as Black, who said they experienced a range of behavior. The behavior really did range from, racial slurs and name calling and racist nicknames to differential response to performance issues, differential discipline, being stereotyped as slow when there was no evidence to support that stereotype. It's interesting for a couple of reasons. The first is the employee brought their complaint in June 2012. So now you're operating the human rights system. This is from June 2012. Initially they brought their concern. They were interviewed in June 2012. The respondent was interviewed in August 2012. Nothing happened after that. So by October, the individual had gone to the Human Rights Tribunal. Then they were subjected to, they said they were subjected to reprisal, called a rat. And so by July 2013, they had left the workplace. 2 months after that, the respondent conducted the final interviews of the investigation, now 15 months later, and found, due to a lack of witness recall and the disappearance of some evidence or the inability to access some evidence, that the allegations were inconclusive, unsurprisingly. So first of all, there was just some criticism of the investigation process as being, quote, poor, the timeline being unjustified. And what was interesting is that there was a sense in the decision that stereotypes about the respondent were part of the reason for the delay in conducting the investigation. Things like the stereotype that when people complain about racism, they're playing, quote, the race card. That people who say that they're experiencing racism are being overly sensitive to the experiences in the workplace. Some suggestion that the individual had contributed to the interactions, and that was somehow part of the justification, I guess, for not immediately taking the concerns seriously. So it was some interesting discussion and a good reminder, to ensure that when we are doing this, it's all kind of blending together now. When we're doing this triage at the beginning of the process and deciding how to approach something, ensure that stereotypes are not informing those decisions. And that may be you as an individual, that may be you as counsel for your employer client, sort of keeping an eye out on their decision making and how they seem to be discussing their decision on how to approach these things. The other thing, and I'll just note this because I just don't have time, is if you want to read a really great decision on how you have to sometimes draw inferences from evidence in the absence of direct evidence when you're trying to determine when someone's experienced racial discrimination in the workplace, to really dig in on the fact that you don't always have direct eyewitness videotape, smoking gun type of evidence, but you can still find racial discrimination based on inferences drawn. This case has a really elegant discussion about kind of the contextual approach to conducting racial discrimination investigations, and some reminders of some things to keep in mind at the decision-making stage, right? Race doesn't have to be the factor, it needs to be a factor, for example. And so, no need for intentions to stereotype when you're applying the stereotypes, right? You don't even have to realize you're doing it if the stereotypes are evident from the behavior. So, if this is, I would really encourage you to read this. I thought it was a nice decision and a really good example of how to conduct one of those analyses, which I know even as external investigators, those can be the more difficult cases to investigate and make findings in. So this is a good example for you if you're interested. And then lastly, this is a situation of the griever and B walking in the hallway, some physical contact. The griever said that the contact was intentional and that B had assaulted them. B said it was accidental. Internal investigation conducted, no findings of an assault, so the allegation unsubstantiated. So the griever brings, the grievances are that they were assaulted by B and that the organization's internal investigation was tainted by unconscious racist stereotypes. B brings their own grievance about their treatment during the investigation process, even though the result was arguably in their favor, but also seeks to intervene in the griever's grievances. And despite the fact that the arbitrator noted that third-party participation is exceptional, they considered a couple things in their decision to allow them to intervene in part. One, they noted that the interest of the employer and the interest of B might diverge. Right, that the employer wasn't particularly invested in an outcome as to whether or not there was an assault, because they'd found there was no assault, they'd taken no action, so they weren't trying to defend some disciplinary action they'd taken. They were fairly disinterested in the outcome of that grievance, but B was hugely interested in the outcome of that grievance. And second, one of the things that the griever had sought as a remedy was to not work with B ever again. And they acknowledged that if that remedy was granted, one of them might have to transfer. So there was a very significant potential impact on B's employment if the grievance was successful, because they might be transferred. And so for those two reasons, the decision was made to allow B to participate as a third party in the grievance related to whether or not there was an assault, but not in the grievance related to whether or not the internal investigation was racially biased. So we had, for those of you who heard Janice last year, there was a case there about a complainant who was seeking to intervene and was given intervener status. This is kind of the reverse of that, where a respondent.
But that was in a wrongful dismissal action.
Yeah, different context, but this is a situation in which the respondent successfully sought to intervene based on the factors that I mentioned.
All right, well, thank you so much, John, Janice, and Cory. Much appreciated. For those of you who have a little time, please do join us for a cocktail. And if you have any further questions, you could perhaps ask them of our panel. Thank you.